Hello, well here I am in Richmond Park, a 2,500 acre deer park in southwest London, just next to Richmond, unsurprisingly in Kingston upon Thames, and then bordered on the northern side by Roehampton. You can see just behind me I've got a special guest who's appearing, which is a deer, which is good because he's keen to hear about the case of McGrath and Wallis, which is a 1995 authority on the presumption of advancement. It's a very interesting case, not least because it stands as authority for the proposition that only very slight evidence is needed in some instances to rebut the presumption of advancement, the idea that there's been a gift between a parent and their offspring. So the facts briefly stated in McGrath are this. You had a father who was a widower, an unemployed widower, who was living with his son. We'll call the son W. He also had a daughter. We'll call her P. Well, as I've said, he was unemployed was the father. So the father and son moved properties. They moved to a smaller property. They downsized. And so as to be able to afford a mortgage, that new property was put into the name of the son. So prima facie, he's the owner. However, in due course, when the father dies intestate, P, the daughter, of course, contests this position because she wants some of the estate. So eventually it goes up to the Court of Appeal, where they have to consider both the idea that the property is of course held in the son's name, but they consider what the reasoning for that might be. And of course, as I've told you, the father was a unemployed individual, so the only way that they could get a mortgage for that second property was for it to be in the son's name, and he of course was in work. So that fact alone, the Court of Appeal were able to identify as being sufficient to rebut the presumption of advancement, that there'd been a gift of that property to the son, and as a consequence the estate was divided up so that the son held 30% and the other 70% was held on trust for the entire estate. So that's to say available for potential distribution to P, the daughter. There was another factor that you should bear in mind in terms of facts, which is this, that after that conveyance for the second property had occurred, the father and son approached a solicitor to organise a trust deed that talked to the passage of property, the idea that the presumption, to guard against the idea of the presumption being rebutted, presumption of advancement that is, but that deed was never executed. That in itself might be indicative, the Court of Appeal held, of the father not wishing the son to receive the entirety of the property. So, from here in Richmond Park, I bid you goodbye and I hope that you enjoy reading McGrath and Wallis and think about only slight evidence being used to rebut the presumption of advancement. So from here, goodbye.